Perfect, perfect. Let's just go ahead. Yes, so complaint procedure under PoSH. So for this, I will be covering history and legislation for PoSH. What is sexual harassment? What is not sexual harassment? How is the constitution of the internal complaint committee is happening under the PoSH Act? And when does the local committee comes into the picture under the PoSH Act? How is the complaint lodged? What is the procedure for dealing with the complaint, which are companies, which would be our potential clients? They would be having a procedure to deal with such sensitive complaints. And then at the end, we will be taking a look at a few cases wherein some judicial interpretation has been given in a manner in which the complaint has to be dealt. So starting with the history, objective, and legislation of sexual harassment. What is the purpose of bringing such an act into the purpose is that lately, a decade ago, lots of women started to step into the workplaces. Earlier, they would not work so much outside their home. But now the era has come, the society has evolved so that the women are taking up roles in the workplaces, they are going out in the offices, going in the institutions, they're going in the laborer works, etc. So therefore, a need was arisen, and Supreme Court had to come into the picture through Vishaka and others versus State of Rajasthan, wherein it detailed guidelines for each and every company or the workplace, wherein they were mandated to have a procedure in place wherein if sexual harassment takes place, it has to be dealt with it and justice has to be granted to the victim. And it is not just the Court of India. There is the Elimination of All Forms of Discrimination Convention. It's a UN convention. Article 11 of it talks about all the parties which have assented to this convention to have a complaint redressal mechanism in place so that sexual harassment complaint can be addressed and can be gone through, can be gotten through until the end of justice. So basically, it provides for safe and secure and enabling environment to every woman, irrespective of her age or employment status, which shall be free from all sexual harassments by fixing the responsibility on the employers and the district magistrate of that local area. So this is a statutory requirement. If these mandates are not followed by the companies, your clients, which will have to conduct posh compliances, they will undergo penalties, which we'll talk about later during the course of the presentation. Also, this act not just provides for the redressal of the complaints, but it also provides for the prevention and prohibition of the sexual harassment which may be taking place against the woman. By so the companies are bound to conduct awareness programs, training of the employees in terms of the POSH Act, so that such action does not take place and it can be taken away, it can be hindered, it can be restricted so that men know that this is what it is, this is the law, and you are not allowed to do this. You cannot put a person in such a situation that they are forced to comply to your demands in fear of retaining of their employment. So this is it about the history and legislation, that this is how the laws have come into the picture. Now we go to what is sexual harassment. So basically, sexual harassment is a form of gender discrimination. It can be either direct or by implication by any one of the unwelcome act or behavior of the respondent. When I say respondent here, respondent means a person who is in a position to sexually harass a woman at her workplace. It can be in any form. For example, physical contact and advances like a pat on my back, which may not be just a pat, but it may be a different act, like they are trying to feel me or something. A demand or request for sexual behavior in return of few perks, in return of promotions, in return of, okay, you will get this if you give me that. So such behavior is prohibited under the POSH Act. Making sexually colored remarks, making um, comments on someone's dress, making comments which is not very appropriate for a ladylike behavior. Such comments are also prohibited under under the PoSH Act. Showing pornography, which is evident by what it says. Any other welcome physical, verbal, or non verbal conduct of sexual nature, which has the capacity to put an employee in such a situation that there is anxiety in her, there is fear in her, there is any emotion which makes her uncomfortable in her workplace, which is unreasonably interfering with her work performance or creates a hostile working environment for her. So this was also laid in Union of India versus Mudrika Singh, wherein it was held that such behaviors are against a gender, a female class, which is discriminatory in nature. Therefore, it is against Article 14, which is gender inequality of Constitution of India, of course, Section Article 15, which is a restraint against discrimination on the basis of sex, caste, creed, religion, etc. Article 19, a woman's right to perform any trade, business, or profession. Article 21, right to life, which also includes a right to life, to a dignified life for a woman. So, all of these acts, which we have just talked about, have been held to be violative of Article 14, 15, 19, and 21. Therefore, this act. And this has been properly explained under Section 2N and Section 3 of the PoSH Act. Going further, then comes, this is the most important compliance any company has to do, which has employees of more than 10. More than 10 employees are there. If 9 are there, they are not required to have a PoSH committee, which is internal complaint committee. However, if they have 10 or more, they are required to have an ICC in-house. So what happens is Section 4 provides for that. Every employer in writing shall constitute a committee comprising of the following members. One has to be a presiding officer who shall be a woman of a senior level. It has to be a woman of a senior level. And then secondly, not less than two members amongst employees, preferably committed to the cause of women. Having experience, it is a preference, it is not a mandate. So two members can be amongst the employees, and one member has to be out of the senior level and has to be a woman. And lastly, one member from an NGO. This is an external member. This one is not from the employees of the establishment we are talking about. Now the rider over this is at least one half should be woman. Whatever number of, and also one more thing I should tell you, that this is the minimum number of members you can have, but a company is free to have even 10 members, 15 members, or even 5, 6, 7 members. However, 4 is the mandate. 3, 4. Yes, 4 is the mandate, and out of which, no matter how many number of members a company may decide to have in its ICC, which is Internal Complaint Committee, they half of them should be women. Going ahead, and yes, and then the LCC, Local Complaint Committee. This comes into picture when an establishment does not have more than 10 members. If they have like 5, 6, 7, 8, 9, any number which is below 10, a local committee of that jurisdiction will have the district committee, the district I'm so sorry, the district magistrate will form a local committee of that jurisdiction, which will come to be known as a local complaint committee. This is provided under Section 6 of the PoSH Act. And then Section 7 talks about the composition, the tenure, and other terms and conditions of LCC, with which we have no relevance with us right now, because we are talking for the compliances of the company. All the compliances under section are given for the district magistrates to take care of. You don't have anything to do with this. Then going further, also one thing I would like to point out, if a complaint by a victim is against the employer of an establishment, then there is much more probability that the internal committee may be biased against the employer. So therefore, this complaint can directly go to the magistrate's local committee, local complaint committee. So this is very important point that one has to note here. Going ahead. Now, so far we have talked about ICC and LCC. Now we know ICC has to be mandatorily there in a company which has more than 10 members, employees. And if not, if more than 10 members are not there, then LCC comes into the picture. And if in case the complaint is against the employer, then again LCC comes into the picture. Now, this till here, I have built up what exactly is PoSH. Why did it come to why did it come into picture? How the committees are framed? What is mandatory and what is not? Now, going ahead, how do we deal with complaints? How do we receive complaints if we are representing a company here? So, from the company's point of view, Chapter 4, Section 9, read with Rule 6 of the PoSH Act. What are the essentials of complaint? So the the most important point here is any aggrieved woman of the establishment can file a complaint. This complaint has to be in writing. It has to be addressed to the ICC, Internal Complaint Committee, and this complaint has to go within a period of 3 months. However, if the incidents are recurring, like they keep on happening, there is not just one incident that is happening, then the complaint has to be filed within 3 months from the date of the last incident. Now we talk about Section 2A here. When we talk about the aggrieved woman, the definition of the same is given under Section 2A of the PoSH Act as well, wherein this woman can be employed, unemployed, ad hoc, intern, assistant, anybody of any age can be an aggrieved woman. For further reference, you can always refer to the Bare Act. Next, if the woman herself is not able to make the complaint, then the legal heir or any person, or even the National Commission can file a complaint on her behalf. Her legal heir or any person who is known to the incident can file a complaint on her behalf. With respect to the last point, within a period of 3 months, this period can be condoned by the internal committee if they think there are bona fide reasons and there were some genuine reasons that the complainant was not able to file the complaint in time. These reasons also have to be recorded in the report, and why the condonation was done has to be recorded by the ICC. So before going into the complaint, when the complaint is made, the ICC can tell the complainant that there is another procedure available for you. If you don't wish to go to the inquiry, you can have this conciliated, which is a settlement with the respondent. So in such a case, inquiry does not happen. Only conciliation happens, and whatever the settlement is made between the parties, it is recorded by the ICC, and such a report is then forwarded to the employer and the parties. So, but it is very important. It has to be with the consent of the complainant. ICC or the company cannot force the parties to get into the compromise, and it cannot be a monetary compromise. And this is provided under Section 10 of the conciliation. What happens if conciliation is not the agreeable term to the complainant? Then an inquiry is gone into. ICC conducts the proper inquiry. It is provided under Section 11 of the PoSH Act. Inquiry to be made in terms of service rule of the establishment. So every establishment usually have a service rule booklet with them, wherein all the terms and conditions of the administration are laid down. However, if these terms or condition or service rules are not there in the company, then they are always bound to follow the procedure which is provided under the PoSH Act itself. We are going to talk about it in the coming slides. If prima facie case is made out, so I'm talking about this Section 11 mandates here in right now. So if prima facie case is made out, What is the prima facie case? Prima facie case, when a complaint comes near you, complaint comes before you and you read it, and you can apply your brain and make out, yes, a case, an incident of such a nature might have been happened. Like, you don't have to get into the evidence of it, but on the face of it, a case is made out, sexual harassment is made out. So then what the ICC does it, they forward the complaint to the police. This has to be done within 7 days, and the police will register a case under section 409 IPC. Now, what is 409 IPC? 409 IPC is an offense wherein words, gestures, or act intended to insult the modesty of a woman is punishable. It could be other offenses also. However, 409 is mentioned in the act, and there is no bar to mention anything else as well, other offenses as well. Now, when the terms of conciliation are not met by the respondent, then inquiry happens, as I told you before. What is required to do while inquiring into the complaint is to follow the principle of natural justice. This is also provided under Rule 7 of the PoSH Act, and the internal complaint committee is free to make out its own framework to address to the complaints. However, they have to be very sensitive while dealing with the complainant, the respondent, and the witnesses. The guidelines provide to keep the name, address, and the name, address, and the identity of such witnesses in a concealed manner. Everything has to be written, everything has to be documented. The witnesses, the complainant, and the respondents are examined individually and separately. They have to take utter caution to make sure that the complainant is not intimidated, is not feared by by the respondent, and they have to ensure utmost secrecy about all the proceedings here. The ICC also have the power of the courts under the CPC, which is for summoning of the witnesses, producing of documents which may be which may be with the respondent, or any other department of the establishment, and so on. To be the statement on oath is also taken under this power of the ICC, which is granted by this section 28, section 11. And then the last mandate is the proceeding by the ICC into the complaint has to be concluded within 90 days. However, if they go ahead, they have to record some reasons for it, whatever bona fide reasons might have prevailed that time. Apart from this, Rule 7 also provides that 6 copies of the complaint has to be provided to the committee with supporting documents and the names and addresses of the witnesses. Within 7 days of the above, a copy needs to be sent to the respondent. One of the copy of the complaint has to be sent to the respondent. And then when the copy is received by the respondent, he has to file a reply within 10 days along with his evidence, if any. And then PNJ, principle of natural justice, has to be followed, which generally means an opportunity of being heard has to be given to the respondent. This is very important. ICC has to follow PNJ and document everything that they are doing in the course of the inquiry. No legal practitioner, like we lawyers, are not allowed to represent the respondent or the complainant for this. They have to do it on their own. All we can do here is impart them quality knowledge and training so that they are able to effectively conduct the inquiry. And last point for inquiry into complaint is that the quorum has to be 3 members. There can be a committee of 5 members. However, when the decision is made, there has to be minimum 3 members to decide whether sexual harassment was made out or not. Going ahead, how inquiry report has to be. Now, this becomes a very important point here because when an inquiry report is challenged before the court, it has to look recent, it has to look thorough, it has to look detailed. So the inquiry committee should make sure that they examined all the witnesses well, separately, individually, however the circumstances required. They detailed everything. They refer to the SMSs, email, CCTV camera, if any was produced. They have to refer to everything. They have to tell how PNJ, how principle of natural justice was followed, how how the conduct of the complainant was, how the conduct of the respondent was. All of this has to be taken into picture for the internal committee, complaint committee, to come to a finding that sexual harassment was taken place or not. So this is how a detailed inquiry report should look, and it has to stand the perils of the courts, all the challenges it may be taken again. So it has to be a proper report, almost like a judgment. Then the copy of the findings has to go to the employer within 10 days after the decision was made. Action to be mentioned: if the sexual harassment allegations were proved against the respondent, there can be actions mentioned. If the service rule book provides for that, well and good. If not, then they can do so as per the act, which can be counseling, termination of the services, decrease in the hierarchy in the establishment, like demotion. There can be compensation, which has to be determined for the victim, and so on. And if no action has to be taken, even that needs to be mentioned in the inquiry report. Going ahead, when this inquiry report is handed over to the employer has 60 days to comply with it. He has to comply with it within 60 days. And then section 18, which is the appeal. If the respondent or the victim or the complainant is not satisfied with the victims, they can always make an appeal before the court or the tribunal, whichever has the jurisdiction over it. Now, during my experience of litigation, I have come through various cases wherein when these inquiry reports are challenged before the court, what happens is, one of the moot questions is that internal committee wasn't formulated properly, which is one. Whatever internal committee has been constituted by the employer in terms of the PoSH, or if they have agreed to take in more members than what they have mentioned, than what has been mentioned in the act, they have to comply with it. As per the act, the mandate is to have 4. However, there is no caps to have them for them to have more members than 4. So, but if they are mentioning 10 members, 10 members should have been there to go through to conduct the inquiry and come to a conclusion. So this was one of the this is one of the various moot questions that comes up against inquiry report. Another one is principle of natural justice. Now the act only provides, it only says principle of natural justice has to be followed. However, it does not say how it has to be followed. But in courts, it is very common to conduct cross examination. However, we are not advising the companies to cross examine the witnesses and the complainant by the respondent himself, because it creates a environment of hostility for them. They may feel fearful, they may feel anxious, they may feel intimidated. Therefore, it depends upon case to case that an opportunity to cross examine is to be given or not. Like, for example, in this Baiduk Chakrabarti versus Delhi University and others, the respondent was entitled to cross examine. Supreme Court gave them the permission to cross examine the complainant. However, since the identity of the witnesses had to be kept concealed, they asked them to present a questionnaire and do it in the form of question and in writing only. They were not allowed to be face to face to each other, so that the inquiry can take on smoothly, and no problem is caused to the complainant or the witnesses. So it was held by the Supreme Court that IC can access need to give an opportunity to cross examine. However, it may vary from case to case, and it is not a mandate. Likewise, in Dr. R.K. Pachauri versus Union of India, in this case also, the ICC confirmed the allegations of sexual harassment and protection of witnesses is valid consideration for excluding the opportunity of cross-examination. So therefore, in this case, opportunity of cross-examination was not granted to the respondent. So this is all.